in the compromise petition, I undertook to pay all the educational expenditure of a child, minor child, who was born in America, but and decided to end their marriage, tied by a decree of divorce. Accordingly, the respondent has paid a sum of rupees 15 lakhs to the petitioner as a permanent alimony. I am getting a 2 lakhs rupees. I am a software engineer. 2 lakhs rupees. After that is a take-home salary. Gross income is 2.83 millions. Now I am taking all educational expenditure, which comes to 30-40 lakhs. Now the respondent is working as a lecturer in business management and getting around 40 to 45 lakhs.
You have no difficulty declaring her as a guardian of the child. Only you want visitation rights, nothing else.
I am prepared to accept
No, 1 minute.
for any terms and condition which is reasonable, my lord, in the interest of the son. I am prepared to.
May I submit?
Even if she is willing to come and join, I will receive her. That's the position.
My lord, decree of judgment of divorce passed is not a consent decree. It is a decree of, it is a judgment of divorce which has been passed where there is not a whisper of anything relating to do with the child. Neither custody, nor visitation, nor guardianship, nor maintenance. Since I just moved to Bangalore, GNWC can be filed as per the provisions only where the child is ordinarily residing. Here for the caveator respondent wife, my lords.
This is a case where in the Gulbarga family court, the matter got settled. 31 1A petition came to be allowed. And in the compromise petition, I undertook to pay all the educational expenditure of a child, minor child, who was born in America, but still they have been subjected to the jurisdiction at America. Sorry, the Gulbarga court. Now, my lords, there is a visiting rights agreed between the parties every Saturday and Sunday to the father. This is a father's petition. Now they moved a 7 GNW application here after the decree, and we filed Order 7 Rule 11 application. Once there is a compromise in the Gulbarga court, any differences will have to move before that court only. There is no question of an independent application filed before the Bangalore court, that too when the divorce petition was pending. The GNW petition was filed.
Let us see that compromise decree.
Yes, my lords. Further, it is to be taken note that the respondent in his affidavit evidence has denied all sorts of allegations of cruelty made against him. However, he admitted that subsequent to filing of this petitioner, in view of the intervention of the elders and the well-wishers of the family, the respondent and the petitioner have settled their dispute out of the court and decided to end their marriage, tied by a decree of divorce. Accordingly, the respondent has paid a sum of rupees 15 lakhs to the petitioner as a permanent alimony. Accordingly, the respondent has no objection to allow the petitioner to dissolve the marriage of the petitioner and respondent by a decree by it is to be taken note that the petitioner has not chosen to cross on so. Then, my lord, there is a reference to 15 lakhs. The operative portion of the decree is at page 51. The petition filed under 31 1A.
Where do you get about the visitation rights?
My lord, your lordship takes at page 27. It is an extracted. Para 16, page 26. It is a case of the specific race, ink page 26. Para 16. It is a specific case of the respondent. There was a
It did not
settlement.
find part in the decree.
Yes, my lord, that is a problem. In fact, I am abiding these terms of the, but I am not having any visiting
When
rights.
is this compromise decree passed? Please come.
But
to
I
me.
am prepared to, whatever your lordship suggests so far as bringing up a child is concerned, I am prepared to do
No,
it.
let us see, first on the technical aspect of it.
Yes,
Then we
madam.
will go to the other issue.
In fact, all that, my lord, I am only appealing to your lordship In view of my Lord Justice Ravindra J. Judgment 2005 6 SEC 566, wherever there is a compromise, there is no appeal, no review. Parties are relegated to only that court. In fact, I suggested to this.
No, but unfortunately.
No, I
This-
suggested, since instead of having one more trial before a district judge, we can have, my lord, via media here itself. All that I am interested. I am getting a 2 lakhs rupees. I am a software engineer, 2 lakhs rupees. After that is a take home salary. Gross income is 2.83 million. Now I am taking all educational expenditure, which comes to 30-40 lakh. Now the respondent is working as a lecturer in business management and getting around 40 to 45 lakhs. Even if she is willing to come and join with me, I am prepared, number one. Number two, whatever, my lord, your lordship suggests so far as the reasonable medical and educational expenditure, I will advise the petitioner to pay it off. But I want a visiting rights on Saturday and Sunday, where it has been agreed, my lord, in the
No,
compromise.
let's go to what is the order impugned? That we will see and then. we will
Annexure
go to
A,
the-
my lords,
pa-
13th of June,
Page
2024.
number.
Page number 16, IA number 5, I filed an application stating that there is already a compromise. So the matters have been settled. Therefore, if at all there is any extra claim, she has to go to Gulbarga court. And the court held that the application is not maintained.
You have no difficulty declaring her as a guardian of the child. Only you want visitation rights, nothing else.
Of course, my lord, that is the compromise which has been made.
What is the
Sir,
difficulty?
I am
Why can't my
prepared to,
lords-
I
why
am
can't you have
prepared to
visitation?
accept.
No, 1 minute.
For any terms and condition which is reasonable, my lord, in the interest of the son, I am prepared to.
May I submit?
Even if she is willing to come and join, I will receive her. That's the position.
My lords, in the court in Kalburgi, divorce petition was filed by me. There is no compromise petition as my
No,
learned
that I
friend.
have seen. I'm
There is no,
saying-
no, I want to submit an IA under order 7 rule 11 is filed for dismissal of my guardianship and custody case on the ground that orders on guardianship and custody are passed. By a compromise petition, my learned friend, my learned senior counsel has submitted. The decree of judgment of divorce passed is not a consent decree. It is a decree of, it is a judgment of divorce which has been passed where there is not a whisper of anything relating to do with the child. Neither custody, nor visitation, nor guardianship, nor maintenance. I just want to make a submission, kindly see.
I've seen that order.
Yes, my lords have seen that order. And the only submission made there was that they went, they settled on a permanent alimony for her for 15 lakhs.
Yes.
On that, noting that the order is petition under this by petitioner wife is allowed, marriage between them is dissolved, and the court records that the 15 lakhs has been paid. It is not a consent decree or a compromise decree. Thereafter, I have nothing about the child. I don't get any order on on maintenance for the child or guardianship, and I'm constantly being threatened that they will take away the child from me. So I filed during the time when this petition was going on. I also, since I have moved to Bangalore, GNWC can be filed as per the provisions only where the child is ordinarily residing. So I filed for.
When did you come to Bangalore?
I came to Bangalore, my lords, just after the petition was filed there, I moved to Bangalore here because I started doing a course. I started studying because I was thrown out of US. I started studying here and I moved to Bangalore. I filed my GNWC in Bangalore. What the learned family court judge has very clearly said, may I just refer to page 24 onwards. This is not some general thing that every matter can come before the Honorable High Court and all matters can be opened up. There is a proceedings going on. Kindly see, my lords, page 24, para 12.
Yes.
May I read from para 12? It is well settled law that at the time of considering an application under Order 7, Rule 11 of CPC, the court has to scrutinize the averments in the plaint. At that stage, the case of the defendant in the written statement is wholly irrelevant, as the application for rejection of plaint has to be decided only on the averments in the plaint. If clever drafting has created the illusion of a cause of action, it should be nipped in the bud at the first hearing by examining the party under Order 10 of CPC. This principle is laid down by the Honorable Apex Court in decision in so-and-so in case of Church of Christ Charitable Trust versus so-and-so. Next, para 30. Para 14. It is the specific case of the respondent that custody of the minor child is already settled in MC number 286 of 21. Therefore, the present, my lords, have seen para 14.
Yes.
Therefore, the present petition is barred by law.
No, I'm with you on that.
Yes.
So we don't have to go further
Yes.
on that.
So
Yes.
the dismissal of the IA, this petition is filed impugning the order, dismissing their IA under Order 7, Rule 11. Now, I have filed for, I am seeking maintenance for the minor child. My learned friend says, I will give anything. He has merely stated in his own affidavit of evidence in the divorce petition that I will give 3,000 rupees and school expense for the child. That is his own unilateral wish. There is no settlement. There is absolutely no settlement arrived at. In fact, even the GNWC case was referred to mediation, and he refused to pay any reasonable maintenance. I have filed my affidavit of assets and liabilities. I have filed an application for maintenance of the minor child.
Let him file his appropriate application, please.
Yes,
ask.
exactly. Let
IA
But all the
IA for restriction
kindly-
rights and all.
he can file it.
page 27 minutes.
Yes.
In page 27, I am paying whatever I agreed in the affidavit. Number one, why there should be a dispute, my lord, between the welfare of a child, between these two people, husband and the wife. Both of them are earning, and I agreed to pay 3,000. Then, my lord, the educational expenditure which I am paying, there is no denial. It has been recorded. Now, the short question is, I am entitled for a visiting rates, my lord. on
Correct. When you
Saturday.
file an appropriate application before the court, it will consider. If it doesn't consider, we'll consider. If you come before the court, now as far as rejection of plaint is concerned, it won't arise. That order has to be upheld.
Your lordship, I will permit it to withdraw the petition with liberty to move an application.
The